Wasatch Report, shooting straight on everything from prepping to politics.
Well, good morning, everybody, and welcome to the Wasatch Report. I am your host for the next hour, Suzanne Sherman. You've tuned into the Cerberus Radio Network, where we defend freedom and liberty from the flames of tyranny. We usually go live, Jeff Johnson and I, back to back with his show, The Paradigm Shift. He just finished his a few moments ago. We try to go Mondays, but we are working people with a lot to do. We're both a little bit under the weather this week, so we kind of took a powder early on. But here we are, bright-eyed and bushy-tailed Thursday morning, March 29th, year of our Lord 2018. Jeff Johnson, again, he did his show, The Paradigm Shift. If you missed it, he was on fire. Go to our Cerberus Radio Network page on Facebook, facebook.com/Cerberus Radio Network. We will have the links where you can just click that and listen on YouTube feed at your leisure. It will also be replayed tonight on our Radio Co app for the Android. We'll get a schedule for that for you momentarily. So want to invite you to check out our free app. By the way, it is for the Android platform, and when you go there and click on it, we have Radio Co programming. It is we have 24/7 quality programming. I have to say I'm very proud of the shows we have, the hosts we have. Like I said, Jeff Johnson, host of The Paradigm Shift, was on just before me. He and Daniel Bailey have a show. They're the founders of the network called The Renegade and the Rambler. They have a special, Daniel Bailey has a special Easter presentation this Sunday. And Daniel Bailey also has his show when he gets a chance to do it called The Bailey Report. We also have Mike Meharry, the communications director from the 10th Amendment Center, has some fresh podcasts that are up. We have some old ones that he does with Shift Gold, Peter Schiff and Shift Gold podcasts. So if you're interested and have not heard these yet about the pluses, minuses of investing in gold, that's there for you as well. And again, our newest show, The Other Side, with hosts Justin and Michael. They are high school teachers that have a really refreshing perspective on many things. They had a great show on Lincoln a while back. They really get concepts of federalism. If we had teachers in our school systems, I might give an inch on government schools if the teachers were all like Justin and Michael. So, but they're not. So we are fortunate enough to have them on our lineup, and you can hear their wisdom. Anyway, also we have Brush Riders of Freedom replay, rebroadcast. That is a show out of Tucson, Arizona. You'd really like that one. We do have a YouTube channel. My understanding is that we're going to try to move away from YouTube and get over to SoundCloud and have downloadable content. And we are working on that, as well as our own website. We're working on that coming soon. Any webmasters, web designers out there want to help us out? We are practical, not proud. We would love to get some assistance in this matter. Again, you can find us on Facebook for now, facebook.com/Cerberus Radio Network. Our fan page is called CRN. You can find me on there also, Suzanne Sherman or Cowgirl Esquire. We also are on Gab, gab.ai. It is kind of quiet there. People do like their access methods that they're used to. And Facebook, let's face it, has become our morning paper, so to speak, our afternoon, evening paper. It's just there whenever we want it. It's very user-friendly, and problem is you just get locked out all the time, and they really are censoring our content. And we know they've been data mining for years. You can also hear me on K-Talk Radio. That's in Sandy, Utah, 1640 AM. I am on Tuesday mornings on the Inside the News show with Paul Jensen. Jason Anderson, his host, will be joining me on Monday, and we're hoping to make that a regular deal. Jason's got some great talent. I really like his outlook. There are a few things that we disagree on, and we'll have some pretty lively discussions about those. One of them will be immigration and the federal authority to regulate immigration. And he will be debating that with me next Monday, so you won't want to miss that one. I am also going to be a regular participant on the afternoon drive show, and that is called Shooting Straight with Maxon, Platts, and Shurtleff. Mark Shurtleff, he's actually a former attorney general for the state of Utah, so that should be interesting as well. And they've allowed me to come on. I was on Friday, and then again last minute on Monday with Shiloh because Mark was all out. So the two of us had a chance to really introduce the listeners that they really don't get to hear this on the mainstream media, these terrestrial stations. What we talk about here, 18th century ideas for 21st century thinkers. I've been blessed with this opportunity to reach this very large audience and talk again about what you won't hear on the other outlets. For instance, our founding principles. They're learning about state sovereignty, implied powers, nationalism as opposed to federalism. What is a nationalist? What is a patriot? So I'm very encouraged overall at the reception that we are getting. People really seem to be enthusiastic about what I have to say. These are the ideas that we share here. So we are getting a bigger audience, and they're actually coming over to listening to what we have to say over here. It's nice too, coming back to be able to do what we do on our own shows, but we can do it at and get involved in these discussions and really get into the detail. We get a lot of callers on these shows and a lot of commercial breaks. So this is our time to kind of stretch our legs and really get into these issues. And Jeff did a great job earlier talking about Thomas Massey and his interpretation with the budget. I mentioned earlier implied powers, and the other day I just got this in the mail, and it is a notice. Let's see, a 2018 benefit notice. Remember the words implied powers that I mentioned earlier. I'm going to read you this. The Social Security Administration, you should start hearing ding, ding, ding right now, has made funds available. Funds available. This is a Ponzi scheme, folks. They're going bankrupt. As you recall, the Social Security scam came about as part of the New Deal legislation by FDR, one of our most evil presidents of all time. Yes, I said that. And it was supposed to be voluntary. And it was supposed to be, these funds were supposed to be set aside for purposes of retirement. As we know, LBJ, and I think it was 1968, decided to sign this money over to the general funds, meaning now there's no discretion to how they're going to spend it. That brings us into the omnibus bill in a few moments. So, okay, let me get back to this. I just can't help myself. Okay. Social Security Administration has made funds available for final expense planning. Jeff, I know you're doing producing stuff back there, and I try to leave you alone at the beginning of the show while you get everything set up. But if you could take the time to look under Article 1, Section 8 and look at and find final expense authority to regulate funerals, final expenses, and if it's there, I'll shut up. So final expense planning. Also, there is a state-regulated insurance plan program to help pay for what the government funds do not cover for final expenses. Okay, that's the meat and taters of this thing. I'm not going to get into the rest. Couple of issues here. First of all, Social Security Administration, again, powers for that created out of the thin air, out of, again, FDR, New Deal legislation. The expenditures were supposed to remain for that specific purpose. Another Democrat, big government progressive, Lyndon Baines Johnson, signed that over. And here's the word that really got to me. What government funds do not cover? We have state-regulated insurance programs. And here is the words matter. Government funds. Excuse me. The federal government is the only government they seem to be acknowledging here. The states merely have some regulations to cover what the government, capital G for God, is not covering. So this is just another little seed they plant to assert themselves as the supreme government authority over our lives. And by the way, we will help you bury your dead. Absolutely disgusting. want to bring up a little quote here from St. George Tucker. Let me see where I put that one. Here it is. The Congress of the United States possesses no power to regulate or interfere with the domestic concerns or police of any state. It belongs not to them to establish any rules respecting the rights of property, nor will the Constitution permit any prohibition of arms to the people. St. George Tucker, one of our members of the founding framing generation. Jeff, I hear your mic. Go ahead.
All right. I want to read a little Henry here.
All right. I love me some Patrick Henry. Liberty
All right,
porn.
Patrick Henry. Here's his statement on the two taxing powers. In this scheme of energetic government, he's talking about the Constitution, the people will find two sets of tax gatherers, the state and the federal sheriffs. This, it seems to me, will produce such dreadful oppression as the people cannot bear.
Well, there you go. Anything else to add?
Oh, no. I mean, Henry's always on point. I mean, I can always find a quote from Henry that's on point.
What I would not give for Patrick Henry today, it's just Patrick Henry, Samuel Adams, Sean Hoffine, his show actually starts out with a Samuel Adams quote. I might get it right here, but it says, and this is what I mentioned on K-Talk, we need people talking about the stuff that we're talking about here, not just waving their Trump, MAGA hats and their flags, but it doesn't. And here's a quote from Samuel Adams. Because, Jeff, we are not in the majority here. We are out here, the backbenchers. We are the ones that aren't getting the huge amount of ratings. But here, this quote, it does not take a majority to prevail, but rather a tireless minority keen on setting brush fires in the minds of men. And that's what we're trying to do. Set these little brush fires, point out these inconsistencies, the hypocrisy of both sides. Because if we can be consistent in our thoughts, we can eventually learn from past mistakes. And this is one of the great comments that I get from the callers on K-Talk. By the way, we do take callers, 717-467-1736. I don't have a guest today, so you can get through. You can also send me messages on Facebook. You can send them in my private messages, and I'll be sure to get them. But, this is the stuff people have to understand. They want to hear this, and they're saying, at least, Suzanne, we love your ideas, and you are always consistent in your thoughts. Well, what's an example of being inconsistent in your thoughts? Well, if you were up in arms and ranting and raving like I was over the Affordable Care Act, but all of a sudden now you were cheering on. Well, now I think it's dead in the water after the Parkland shooting. If you were cheering on the proposed national reciprocity, guess what? You are inconsistent in your values and ideas. You are not a friend of liberty. So, Jeff, also, you had mentioned, and by the way, I have this little voice thing going on just like you did. So we might be taking a break here and there. I might do 2 breaks today. So let's talk about a little of this omnibus bill. Jeff, you mentioned a little bit about the mushroom treatment where the members of Congress were kept in dark and covered with fertilizer. And again, going back, 18th century ideas for 21st century thinkers. Let's get a little James Madison here. It will be of little avail to the people that the laws are made by men of their own choice if the laws be so voluminous that they cannot be read, or so incoherent that they cannot be understood. If they be repealed or revised before they are promulgated, or undergo such incessant changes that no man knows what the law is today, can guess what it will be tomorrow. Jeff, does this sound like that omnibus bill to you?
Yeah, 2,200 and some odd pages. Yeah, I believe so.
Yeah, they had a day to read it, and I think the only one that
no, it's worse. They had 2 hours.
2 hours?
2 hours to read 2,232 pages, I think he said. 2 hours.
And yeah, I saw him. There was a picture of him with a box of pizza, and he was going to try and get this read. This is absolutely scandalous, and I'm not going to go back into that because you did an outstanding job on covering that. I had a couple other thoughts though, because when I was on K Talk on Friday discussing this disaster, the apologists were of course calling, and I got one phone call on my way home, and a friend of mine said, well, Donald Trump said that he hated to sign this, and he really he's not going to do it again, and it was for our military. And I said, okay, well, what about if you came home and your wife said, hey honey, I cheated on you while you were at work today. I hated to do it, but I had to, and I'm not going to do it again. So what do you want for dinner? And they get away with this. I didn't like it. And why do they get away with it? Because he said we had to fund the military. We had to fund the military. This is why they wanted to have no amendments. The rules where they could not change a thing. You either do exactly what we say, or the military loses its funding. Go ahead.
I said, like during my show, they were given the bill in the Rules Committee. They had 2 hours to go through 2,232 pages and offer amendments. As Massey described, he had an amendment all done except for the page number and the section numbers and all the. He had blanks, fill them out by hand. He everything else was typed, filled it out by hand with those sections that were blank, and turned it in that 2 hours. It had to be 30 copies of that to the Rules Committee.
Yeah.
And then the Rules Committee denied all of them, because there was his on gun control, there was some on defunding Planned Parenthood, there was some on the sanctuary cities. Again, we can discuss that separately. But the fact of the matter is, there were all these amendments to fix the problems, and they denied every one of them. Didn't even allow a vote on them.
And again, hanging it on the military. And when Donald Trump, first of all, should have vetoed this. And I referred people on Friday at K Talk to James Madison's bank bill bonus veto, where profits from the second bank of the United States were going to be used to fund infrastructure. James Madison supported this. Congress gave him this bill, and he vetoed his own bill. Why? Because they failed to amend the Constitution to provide their authority to do so. This is what Trump should have done. This bill was chock full of unconstitutional expenditures. And again, he hangs it on the head of war. And this goes back to the fear of the standing armies. And this is a quote that I put, again, another Madison quote in the article that we had written on national reciprocity, but you can find it here. And this is what he says: of all the enemies to public liberty, war is perhaps the most to be dreaded, because it comprises and develops the germ of every other enemy to public liberty. War is the parent of armies. From those proceed debt and taxes, and armies and debt and taxes are the known instruments for bringing the many under the domination of the few. Boy, howdy, was he prophetic. And here we have it. We have this absolute disaster rammed down our throats. Nobody read it. Why? Because we had to fund the military. Why? Because we are in these non-stop wars. And as it wasn't the problem. The existence of the Army wasn't really the problem going back in time. The problem is what we have now: federal control of the Army. Article 1, Section 8 allows Congress the power for updating the capabilities of the Army. What we have right now is, because we're in this perpetual state of war, guess what? The federal government is in charge of this. So that's about all the time I really want to spend on that one. I had a couple things I wanted to talk about some local issues out here in Utah. One of them is a free-range parenting. Let's see, a free-range parenting law that came out of the state of Utah. Jeff, our government is supposed to jealously guard our liberties, not divvy them out piecemeal as they see fit. But I kind of understand the need for such a law, because we have so many little brown shirt tattletales. We're hearing about parents being punished if their kids are playing in their own front yards unsupervised. Heaven forbid they should walk to the park unescorted, walk to school unescorted. That's the stuff we did when we were growing up. I know that. And you know what, Jeff? I even rode the back of a truck and rode a bicycle without a helmet. How about you?
Same here. I in elementary school, I walked to school. It was 5 blocks over by myself, or if one of my friends was going, at the time I could walk with my friends. We played outside on the road. 15th Street, where I grew up, it was just a little road. We played kick the can or whatever in the middle of the road. If car's coming, we run off the road. The car would go by, we go back out and keep playing.
Yeah, car.
We played. I mean, it was. Kids aren't kids today. They're little mushrooms that need to be grown in the fertilizer of government so that they can become good little Marxists.
Well, here we have, and I love how the article starts off too. I think this was, I'm not sure which webpage I got this off. I just printed it out. The state of Utah has legalized a controversial child rearing method called free range parenting. So apparently, Jeff, what we did as kids is now considered controversial. Governor Gary Herbert signed the bill that would allow kids the freedom to walk to and from school. Here's one that's crazy. Wait in parked cars and visit playgrounds solo, according to a story published Monday by the AP. The bill doesn't specify an age limit for the above activities, but will go into effect May 8th. Senator Lincoln Fillmore said, I feel strongly about the issue because we have become so over the top protecting children that we are refusing to let them learn the lessons of self-reliance and problem solving that they will need to be successful adults. You know, not only that, Jeff, just to keep things easy for the teachers in school, we're drugging them into submission so they can sit still. These kids are never going to learn how to deal with any difficulties that they might have focusing if they're medicated all the time. So the laws don't allow good-intentioned parents to make common sense judgment calls, the laws that they have right now. And the consequences for raising independent kids often carry harsh consequences unless there's real evidence of abuse. A simple decision like a parent leaving their kid in the car while they run into the store doesn't give a concerned citizen the right to start legal proceedings against a family. And we hear about this all the time. If you leave your kid or your dog in the car, that they're going to come and break your windows open. You know, give parents some latitude, give people some opportunities. You know, if somebody's in the car and it's in a safe place, it's in the shade, sometimes it's easier just to do that. And again, discretion is involved. No one's talking about infants, but we're talking about kids being allowed to be kids. Jeff, let's just take a really quick break, and I'm going to reset the table here, and we'll get back with, I'm going to get into Brown versus Board of Education. Is the woman who was the subject of this lawsuit recently passed away, and I'm going to get into that in a little bit. This is a Cerberus Radio Network, and we are defending liberty and freedom from the flames of tyranny. We'll be right back.
Down to keep up with this trucker, Daniel Bailey, in the Bailey Report on the Cerberus Radio Network. Looking for a new custom camo dress or scarf? Tail Gunner Apparel. Looking for bath and body products for women and men? Tail Gunner Apparel. Looking for bed scarves and custom home products? Tail Gunner Apparel. Look awesome and feel even better. Tail Gunner Apparel on Facebook or at tailgunnerapparel.etsy.com. That's tailgunnerapparel.etsy.com. Made love and then you
Remember when. Cerberus Radio Network, protecting liberty and freedom from the flames of tyranny.
All right, everybody, welcome back to the Wasatch Report. I am Suzanne Sherman. Here at the Cerberus Radio Network, we are defending freedom and liberty from the flames of tyranny. Jeff Johnson's joining me in the studio producing right after he did his show, The Paradigm Shift. If you missed it, go back. We will have the link on our Cerberus Radio Network page on Facebook. He was on fire talking about Massey and the omnibus bill and representation and our lack thereof in this government we have today. Hey, Jeff, I was going to get into Brown versus Board of Education, but I remembered I had this quick video clip or audio I wanted to play on Senator Feinstein and her lack of understanding of the very document she took an oath to uphold and defend. Do you have that available to play?
All queued up, ready to go.
Fire away.
I don't think it's possible. I think it's extraordinarily difficult to do. To change the Constitution, as you know, requires 67 votes in the House and I think 35, 45 states to ratify it.
Okay, shut that old bat up right now. That's enough. That's all we need to hear. All right. Apparently, it's too much to ask for this old bat to read Article 5 of the Constitution. This is how we amend the Constitution, Senator. 2/3 of both houses can propose this, or 2/3 of the state legislatures can propose this. Each and every time these idiots convene in Congress, when they start up Congress, they can propose to amend the Constitution. It's not that it's that difficult. It's that they don't have the support. So we're just going to do it anyway because we need to, and something has to be done. That's the biggest threat to our liberty, is the phrase, something must be done. Because when they say something must be done, you know what their plans are, is to circumvent, to throw off the restraints and do whatever the hell they want, okay? We can't amend the Constitution. And Justice John Paul Stevens, retired Supreme Court Justice, proposed repealing the Second Amendment. Hey, stupid. You sat on the Supreme Court, for crying out loud. Repealing the Second Amendment does not grant you the authority, does not grant the general government the authority to regulate a power they were never delegated to by the states. Article 1, Section 8 does not give you the authority to regulate firearms. So repeal away. Jeff, I'm really getting fired up about this. These are the people that the citizens, the subjects, the lemmings turn to determine what the law is. I have a debate. I love Shiloh Platts. I'm on with him on his show on K-Talk on Friday afternoons. Thank God he's open and he's able to be reasoned with. Because he said, if the Supreme Court isn't available to tell us what the law is, we're going to have fighting in the streets. And I said, my friend, if you expect 9 politically connected lawyers in their black government-issued costumes to tell 320 million people what the law is, I submit to you that is precisely why we have fighting in the streets. We had fighting on the eastern seaboard to assure that we would not have this. So when you want to remember those that have sacrificed, think Lexington and Concord. All right? Not the Middle East. That's the legacy we need to preserve. All right. So when we just think these people can do whatever they want, we get cases and infringements upon our liberty, and we justify it. I hear this all the time. When you allow the federal government to take over firearms And when the states are infringing upon our rights, it's a good thing. Why is that a good thing? Well, because, and this is the case that I'm told about all the time, and I'm going to get into this more on another show, it stopped racism. It stopped racism. Case in point, Brown versus Board of Education. This is what is defined, and I'm going to be going out of Who Killed the Constitution. This was a bestseller by Tom Woods and Kevin Gutzman. Absolutely love this book. It has a multitude of topics that describe how the Constitution. I said it was stillborn. I said it was a Trojan horse. We never should have had it in the first place. But now we're going to play by the rules. And this week, let me find that case. Here we have CNN did an article. And Linda Brown, she was the schoolgirl at the center of Brown versus Board of Education, passed away on Sunday afternoon. Good Christian woman, God rest her soul. I don't have the problem with her. I have the problem with, I think what Tom Mullen refers to as our judicial temple monkeys who think that they can do whatever they want. So going to this book, Who Killed the Constitution, this chapter is called The Third Rail of American Jurisprudence, Brown versus Board of Education. Because of a government decision seems beneficial or right, doesn't make it constitutional. We say this all the time. Good intentions don't ensure proper government action. In the long run, good policy outcomes can undermine the rule of law if they are adopted contrary to the actual meaning of the Constitution. There was also a companion case, Bowling versus Sharp, and that was in the District of Columbia. So we're going to combine these two, Brown versus Board of Education, and I'll get into Bowling in a little bit. But these are the most celebrated rulings of the 20th century, and they earned the Supreme Court an unprecedented level of prestige. Again, this is cited to me all the time, that they solve these problems of racism that the states were unable to solve on their own. No one dares to criticize this decision because, again, Saul-Alinsky tactics, you'll be called a racist. Law professors now skip past the constitutional question about Brown. And I am speaking from experience. Yes, they do. In fact, it's not just Brown, it's any of these New Deal policies. This is the problem with the legal education system. We don't study, as lawyers in training, the history of the Constitution. We study the opinions of leftist judges. These opinions always serve to expand the course and scope of the government. The article or the chapter says that this hands-off approach to Brown is really a focus on the policy outcome rather than whether or not there was a justification for it. Few today have the temerity to point out the problems of the Brown ruling. The framers and the ratifiers of the 14th Amendment certainly would have recognized that the decision ran counter to what they intended to accomplish through the amendment. Well, guess what? I have the temerity. I'll say it. Call me what you want. I will speak the truth, even if it makes me not look very good. That's what we're here for. I mean, Jeff, why do we get up in the morning? Why do we do this? Nobody else is telling the truth. They won't overturn Roe versus Wade, by the way. I made this point earlier. There was a case that came out before Plessy versus Ferguson, or before Brown. It was called Plessy versus Ferguson. We learned this in law school, and this stood for the proposition that they could have separate schools for the races as long as they were equal. Separate but equal was accepted. That was found lawful by the Supreme Court. Again, did they have the authority to judge state cases, state policies? No, they did not. They came up with this because of the 14th Amendment. So the justices were aware that the court's 58-year-old decision, this was 58 years old at the time Brown was heard, had been correct in declaring that racial segregation did not violate the Equal Protection Clause of the 14th Amendment. The 14th Amendment was not intended to outlaw racial segregation, nor, by the way, a little side trip here, nor, by the way, was it intended to outlaw prohibitions on abortion or the states deciding what kind of marriages they would recognize. Rather than a legal decision, then, Brown was the justice's statement of a policy preference. They simply disapproved of racial segregation and would not enforce the policy they found so distasteful. This is referred to as a constitutional crisis in this book. To make exceptions for government outcomes that seem right but aren't consistent with the Constitution really sets us up for arbitrary and dangerous distinctions. Doing so, this will break, and this is according to the book here, breaking the chains of the Constitution, that Jefferson's memorable phrase, are needed to bind down the politicians. So once we allow the government to go outside the bounds of the Constitution, we create a precedent for other extra-constitutional actions later. And judging by subsequent decisions that have affected us, that's very clear that this has happened. I'm not going to take, I can do a whole show on what the 14th Amendment really meant. There's a great podcast too with Tom Goods and Kevin Gutzman on this. And if you just do a search with their names and what did the 14th Amendment really mean, you can find that. We'll try and remember to post that on our wall. But really it was the intent briefly was to ensure that the recently freed slaves had the basic rights of citizenship. So it essentially annulled the Dred Scott decision, and by declaring that and it also declared that anyone born in the United States was a citizen of the United States and the states in which they resided. And it forbade the states from abridging certain rights of U.S. citizens in the Privileges and Immunity Clause. It also gave them benefits of due process. Now, what I mean is procedural due process. What they did was turn this into substantive due process and created this whole plethora of fundamental rights that they could use as a springboard by which to overturn state legislation and decisions here. So let me move on a little bit here. So I want to give you some background here. Did the issue of this case was really, did the court have the constitutional authority under the Equal Protection Clause warrant to separate schools by race? Did they have the constitutional authority to decide this? So again, at the time, we have to look at when the 14th Amendment was proposed, because if they had intended it to have this authority over the states and these schools, again, local matters, it would have been discussed in the ratification debates, or it would have been, if you look into the situation at the time, it would have been covered, because here's the point I'm trying to make. At the time it was proposed, 24 of the 37 states had segregated schools. So wouldn't it make sense for them to mention this if they had decided that they wanted to end this policy at the time? Congress segregated schools in the District of Columbia from 1864, and this was not addressed in the issue of the Civil Rights Act of 1875. So these things would have been brought up in the 14th Amendment had they, intended to give the general government the power to regulate schools and the desegregation thereof. So the court's most significant segregation precedent before 1954, like I said, in Plessy versus Ferguson now, said that segregation did not violate the Equal Protection Clause of the Constitution. And I'm going to read this. This is what I like about having our own show. We have the latitude to really get into this and not be interrupted by a break. So the Plessy majority offered very little by the way of analysis in understanding the 14th Amendment's ratifiers beyond saying the object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things, it could not have intended to abolish distinctions based upon color or to enforce social as opposed to political, or as distinguished from political equality or commingling of the two races upon the terms unsatisfactory to another. What are they saying in here? We're not going to impose social engineering upon the states, which is exactly what they did after this. So the laws permitting and even requiring their separation in place where they are liable to be brought into contract do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally, recognized as within the competency of the state legislatures in the exercise of their political power. This is huge. So this really addresses the issue of the state's incompetency to resolve racism. So again, when people say, excuse me, I got to get a drink here. When people say you have to look to the federal government to resolve these issues, well, look what the federal government had already said in the past. We had the Dred Scott decision. We've had Plessy versus Ferguson, which said the states were not incompetent. So, you know, I always wonder when people think that the federal, the national government is the only government capable of coming up with these situations. Jeff, is there a special place from which we farm these representatives in the federal government? Are they somehow distinct and unique from the rest of us? I mean, they do come from our general population, I assume, or is there some factory or some farm where they're brought up and fed this royal federal jelly to make them superior to the rest of us? If I'm missing that, then let me know. So Raoul Berger, even in his book, Government by Judiciary, says that this was consistent with the ratifiers' understanding that the states, remember, were competent to handle these issues. So again, since the federal government had already failed, now we're assuming they're the only venue by which these issues can be resolved. So why did the Supreme Court come up with the ruling they did in Brown versus Board of Education? In the book here, there's a subnote or a subheading called "Because They Could," and that really is where they get the authority. Well, we're just going to grant ourselves this authority. So Felix Frankfurter. Okay, I'm going to back up for a moment here. So the Supreme Court first heard these cases involving segregations in the 1952-53 term. At this time now, we still had 17 states and the District of Columbia with segregated schools. The plaintiffs in Brown versus Board of Education needed a way to explain a historical record on segregation and the 14th Amendment. And then they had to come up with a constitutional justification for a ruling from the Supreme Court. And there were a historian named Henry Steele Commager responded that Congress, there was some research done, the NAACP, Legal Defense and the Education Fund, had this study, and they sought the advice of this historian who said that the 14th Amendment should be used to end segregation in schools, but they could not argue about the original understanding of the amendment could not be used to justify it. Felix Frankfurter had his law clerk do some research, and he said that he reported back to Justice Frankfurter that it is impossible to conclude that the 39th Congress, meaning the Congress that ratified the 14th Amendment, intended that segregation be abolished. It is impossible to conclude that they foresaw that it might be, and that under the language they were adopting. So the evidence was really clear that Congress did not intend to abolish segregation in schools. So now we have this tricky issue. We have these justices that want to impose these desegregation regulations and policies upon the states absent the constitutional authority to do so. The language of the 14th Amendment could be said to be too vague to answer the question as to whether the segregation was unconstitutional. That was kind of a way they had some wiggle room, but it really was not too vague if you look at the history of this. So, Jeff, did you have anything to chime in at this point?
No, go ahead. I'm not.
Okay. So when the matter of segregation was first argued, the justices had been divided nearly evenly, we had a lot of interplay. And in fact, a friend of mine, James Rutledge Rush, sent me an article from American Renaissance saying that there was some extrajudicial workings between the justices and the plaintiffs. I don't know if I'm going to have time to get that today, but I'll probably get it on the next one. But the court here set itself above the Constitution. And Frankfurter said that, let's see. So how did Frankfurter justify the changes? Because as I said, it was nearly divided. They needed to get a unanimous decision, by the way, to really bolster the validity of such an extrajudicial, something that was beyond the realm of their authority to decide. So what he did was he had to identify changes in men's feelings about what is right and just. So we have to go from what are we authorized to do to what is the right thing to do. He could not have meant for such changes to be identified democratically, because what he intended was for the unelected members of the United States Supreme Court to invalidate a plethora of state and local laws enacted by elected state and local legislators. Jeff, as you had mentioned on your show, we wanted a representative form of government. Remember, under the British Constitution, it was not written. They had a system of parliamentary sovereignty. So here we have unelected, appointed officials formulating policy in a manner in which they were never intended, simply because they wanted to. Now, because regulating schools and the segregation thereof was never authorized by the Constitution, to do that, we needed to amend the Constitution rather than interpret an already existing amendment to cover it when it clearly did not. Senator Feinstein, in that recording we played, indicated she didn't even understand how to come up with the constitutional amendment. The Brown Court wasn't even considering that. They weren't concerned with that at all. They were going to have their own constitutional convention and not even invite the states. And that's exactly what they did. So there is no democratic or representative form of government process there whatsoever. The court would now serve as America's supreme legislative body. So why would the justices feel entitled to behave this way? Because they wanted to, and because they could get away with it. So again, Warren, Chief Justice Earl Warren, kicked off his and the court in Brown's opinions by noting that the question raised by the four cases consolidated here was whether it was constitutional under the Equal Protection Clause to segregate students by race. There is no clarity in the historical record supporting what they were trying to do here. What Warren said was that the court, after hearing arguments in the matter in 1952, had requested re-argument in regard to certain matters in 1954, and that this, after extensive consideration for a historical record, had not answered the question of whether banning the segregations had been among Congress's intentions in drafting the 14th Amendment. Here he's lying, because the totality of the circumstances, as we're trained as lawyers to take into consideration, clearly show that they were aware of the existence of segregation, not only in the state public schools, but in Washington, D.C. themselves, and they chose to simply ignore this fact. So what we have here is Warren Court insisted in 1954 could not be bound by the understanding of people who lived in 1868. Once again, the Constitution is a living, breathing document. We have to apply modern terms and just circumvent the will of the states and the rule of law. So they really just made up their mind. This is what is referred to as bald-face imperialism. Also, they had a non sequitur in which Warren lectured on the significance of public education in 1950s America. Public education, according to the Chief Justice, was perhaps the most important function of state and local governments. All of a sudden, public education is the most important function. This is going to justify our ruling, our opinion here, and impose our policy desires on the states. Public education was the most important role of government. Not defending liberty, not enforcement of contracts, not police protection, not fire protection, not punishment of criminals, public education. Public education, interestingly, is the means by which the government indoctrinates future generations into the benefit of big government. See where we're going with this? This is nothing more than what is referred to again in the book as bald-faced judicial imperialism. The Equal Protection Clause of the 14th Amendment affected only policies of state governments, not those of federal district. That was also, see, this is how they also got around this, because the 14th Amendment didn't even affect Washington, D.C., and they used it again to desegregate the schools in Washington, D.C. So the Due Process Clause of the Fifth Amendment, they said, banned segregation in the District of Columbia. So rather than using the 14th Amendment, they used the 15th Amendment, or they used, I'm sorry, the Fifth Amendment Due Process Clause. But this is what they're saying here, and this is what makes bowling equally outrageous. The Fifth Amendment was drafted chiefly by James Madison. James Madison was a slaveholder who never did anything to undermine slavery, referred to the states by a Congress completely or composed largely of slaveholders, and ratified by a number of states firmly devoted to the ongoing enslavement of virtually every person of African descent within their borders. They're trying to say that notwithstanding all of this, the intent of the Fifth Amendment banned the provision of free public school to Black people on a segregated basis, because school segregation is so unjustifiable as to violate due process. So they're taking a condition that applied today, clearly wasn't in the intent, given the circumstances of the time that the Fifth Amendment was ratified, applying it today to what? Justify their policy outcomes. Here's a great paragraph on the infallibility of these justices and the arrogance that these people show. I've quoted him before as well. And this is Justice Jackson. One Supreme Court justice commented in the 20th century, "We are not final because we are infallible. We are infallible only because we are final." The point is valid in relation both to the flawed thinking that can pervade the Supreme Court, I'm going from the book now, decisions, and to the fact that there is no one to appeal beyond the Supreme Court. And this is so true. The Supreme Court has spoken. And this is what's so frustrating, because we have the people that are arguing, well, Roe versus Wade is settled law. You can't overturn it. Well, wait a minute. Why is Roe versus Wade settled law, but Plessy versus Ferguson was not settled law? They had a different policy outcome desire, so they circumvented the Constitution and came up with their own legislation. Now, nobody's saying with Roe versus Wade we have to circumvent the Constitution, but certainly we have a couple ways by which we can stop human abortion. I mean, if we're willing to do this for desegregation, if we're willing to do this for marijuana, if we're willing to do this for gay marriage, why the heck can't we stand up for the most defenseless contingent of our society of all, the unborn? Why do we talk out of both sides of our mouths on this issue? Also, the states can come up and register and come up with this regulation on their own. So again, this point is valid. They are infallible because they're final. When it came to the court's holding decision in Brown and Bowling, it seemed at first as if the people would simply accept the final authority of the court. Governor Herman Talmadge of Georgia explained in his memoirs years later that the Southern political elite had seen the outcome in Brown coming for years, and they weren't even slightly surprised by it. And this is, again, we had this revolution, this judicial coup d'etat in the 1930s with the New Deal court. But sometimes the court isn't the final authority. This is what I try to tell people. I don't care what the Supreme Court said. They are not God. We have other branches in this federal system, also called the states. Rather than comply with Brown, going back to the book, many states and local authorities actively resisted desegregation for many years. One state declared a formal policy called massive resistance. In time, this defiance joined to the justices' frustration with the limited effects of even good faith compliance, led the court to shift its mandates for compliance and to impose a far more radical response to the problem that had ever been contemplated by the Brown court. The next chapter is actually forcing social engineering experiments. And I was actually a victim of that when I lived in San Francisco in the 1970s, and that was forced busing. So, and when I talk about state resistance, I'm not talking about saying, hey, look, the states clearly should be able to desegregate their schools. I'm not saying that. I'm saying that this really is a state issue. Free markets, people voting with their feet will be the ultimate decision makers in these policies. People are going to want to go to the states that focus on liberty. They're not going to want to patronize the states that have such policies. I voted with my feet when it came to California. So again, we have to understand with regards to the states and their ability to fight an overbearing federal government, national government, they are not forced to comply by commandeering. The Supreme Court had said, again, there's sometimes I agree with them, but I am consistent. But I do like that they did this opinion was consistent with the Constitution. They cannot force these states to use state resources to enforce federal laws, national laws. So, Jeff, this whole discussion has really been, this woman died. We need to have a discussion of why this case came about. It was so overreaching, such an egregious, bold-faced jump and anti-constitutional decision they've had. But because they hid behind race, they were able to get away with it. And again, we have to have a court that is consistent. We have to have expressions of federalism that are consistent as well. Because when we have this one national land mass, such a small representative government in proportion to our population, again, even if you account for the members of Congress, 535 altogether, Supreme Court, 9, and then consider all of these unelected bureaucrats, which are really taking over the responsibilities that shouldn't be delegated. All legislative authority shall rest with Congress. It's non-delegable. But we have these unelected bureaucrats, these unconstitutional agencies making these laws. Case in point, also where we jump the shark and where the executive crosses over to the legislative. Jeff, this ties into what you mentioned earlier with the omnibus and King Trump decreeing that bump stocks heretofore shall be banned. So that's all we really have time for today. I want to thank you for listening. We'll be back. I'm hoping to do a show on Monday with Jason Anderson. And I'm going to follow up a little bit more on Brown versus Board of Education. We'll also discuss a little bit more of immigration and anything else that happens to come up over the week. Jeff, I want to thank you for producing the show today. I'm Suzanne Sherman here on the Cerberus Radio Network, defending freedom and liberty from the flames of tyranny.